Welcome to my channel. I am a barrister who helps you understand law. In this video, talking about how do we know when someone is telling the truth and how do we know when they are lying. There's a number of different ways we do this, and as lawyers, our job really is to make someone else believe you, either the judge or the jury. Or in other situations such as tribunals or mediations or arbitrations or wherever it might be that you're called upon as a legal representative to advocate someone's case. Our job is essentially to get someone else to believe you. So let's take a look at how we do that. There's a number of different ways that someone is to be believed or to be disbelieved. Some of them are more technical than others. Some of them have a science behind it. Some of them are just concrete, hard evidence. So we're going to look at a number of different ways of doing this and which ones matter. Let's look at the evidence first. If I were to tell somebody that I have a UFO in my garden, as Darren Brown once said, then the only way that I could prove that, really, is to take a photograph of it, have it tested so that somebody can actually determine that it's from another place and it's not just been made up in the UK, and all kinds of factual, hard evidence, scientific evidence that proves that this is not something that is just manufactured in this world. But my say-so alone is almost certainly not going to be enough, particularly if I'm the one stands to benefit from what I'm telling you. So my statement alone is not necessarily going to be enough. Now, what if I'd previously told people that this is the case, and I've told them a number of times, and then when the day comes, such as the day in court where you're being challenged over this, and I say the same thing, and I say, well, hang on, I've told a dozen people over the last 3 years that I have this thing in the garden. How about that? Because each of those would be a consistent statement with what I'm saying now. But there are specific rules when it comes to statements, and they are known as previous consistent statements or previous inconsistent statements. And as that suggests, they are either consistent with what you're saying now or they are inconsistent with what you're saying now. And this relates a lot to the police caution in almost every jurisdiction, but I'm going to come back to that in a moment because I'll shift to inconsistent statements. Let's stick with the consistent ones first. A consistent statement is sometimes referred to as a self-serving statement. What this means is the statement by you previously is self-serving to what you're trying to prove now because it's essentially the same as what you're saying now. But the important point about this is that it seeks and serves to prove the truth of something stated. And by itself, it's deemed to be hearsay, because we've talked a lot about hearsay in recent videos, hearsay being any statement which is the truth of a matter stated, or taken to prove the truth of a matter stated, to cause a person to act or a machine to act upon the basis that that is true, that is not given in oral evidence. Therefore, if I say it in oral evidence and somebody can test and challenge me on what I say, that's oral evidence, it's not hearsay. But anything written down that attempts to prove the truth of the same thing is hearsay. And that is how, as a standard rule, previous consistent statements are taken, if they are taken to prove the truth of what is stated. Now, why is this important? Well, because let's take the scenario where somebody wanted to commit some kind of crime, but they wanted to sow the seed along the way that they can rely upon later to prove that they didn't do this thing. So let's say that they tell a number of different people that they are not planning to do a certain act, an act of crime. But later on, they are accused of this crime and they say, I've never intended to commit this crime. And then they try to adduce in evidence a dozen different previous consistent statements where they've told other people that they had no intention of ever committing this crime. Then each of those would be a self-serving statement, because this person would have planned all along to produce this self-serving, consistent statement, having then later relied upon it as truth of the matter stated that they never intended to commit this crime. This is why they are hearsay. This is why, as a rule, they are typically not admissible as a starting point, because ultimately they are self-serving. Now, there are some mixed rules before I move directly on to inconsistent statement. There are some rules about a mixed statement, which is whereby if a statement previously made is mixed between inconsistent and consistent statements, then the whole thing should be considered and put to a jury in that sense. But let's move and contradict that with an inconsistent statement. Let's say now that there was an attack upon a person, and the person accused of doing this is saying, I've never had anything against that person, so why would I attack them? If, however, there was a previous inconsistent statement whereby they had previously told another person or written down that they didn't like that person, that they had animosity towards that person, some disgruntled history with that person, anything that is inconsistent with what they're saying now, that is an inconsistent statement made previously, and the rules for this are, by default, the reverse. They are, by default, admissible because it's a previous inconsistent statement. Why might that be? Well, coming to considering this in the nature of this entire video, how can we decide and prove whether someone is telling the truth or not? If someone is making a statement now which is different to what they made previously, then their evidence is automatically less credible because they've changed their story. And so this is where we come on with the best way of explaining this, to explain the police caution, which for England and Wales, I know it differs somewhat in different jurisdictions, but the broad nature of it is the same. It's a warning that if you change your story, then later on there's a negative or an adverse inference against you for changing your story, because the suggestion will be made that you've made up a new account later to evade the liability. So the police caution in various jurisdictions, but for England and Wales, is you do not have to say anything, but it may harm your defence if you fail to mention when questioned something that you later rely on in court, and anything you do say might be given in evidence. So the inherently important portion of that is if you fail to mention something when questioned, and you later rely on that in court. So if you pick that apart, if later on you say that the attack was in self-defense, but you didn't say that at the outset, and any reasonable person would have, or certainly should have, said at the outset that it was self-defense, then it's going to hinder and harm your defense. And this is known as an adverse inference. And this is one way we analyze the statements that have been made, what's been said, and assess the credibility. And we invite a jury to assess the credibility, and we invite a judge, where appropriate, to assess the credibility of the evidence given in court. And then we compare and we contrast that with what has been said to other people. Now, this is where the lines with previous consistent statements and hearsay and everything else sort of blur together a little bit. And so allow me to explain what I mean. Hearsay, remember, is something where you're trying to prove the truth of what is stated, but it is not in oral evidence. So it could be written down, it could be a slogan, it could be a drawing, it could be a photograph where somebody's changed the photograph to make it look like a person's been hurt in the photograph. That in itself could be a statement of some kind of truth where you're proving truth that the person intended to harm. If it's intended to prove the truth of something, there is an intent to harm the person, that might be taken as a statement of truth that someone's trying to prove. Therefore, it's hearsay. Now, there are rules to admit hearsay, but we won't get into those in this video. That'll be a whole separate video on the rules for admissibility, and it's, again, they can be very different in different jurisdictions. But the point of it is this. When you have a statement such as that, which is seeking to prove the truth of something, we test these statements against what is said in oral evidence. So when you have a photograph, and you'll think of recent cases where there have been photographs of different things that either are or are not happening within the photograph. A classic example from that trial just recently, when Camille Vasquez was talking about a table on which there were lines of white powder. But they were neat lines, undisturbed, and she put it to the witness, you know who I'm talking about, she put it to the witness that it didn't look like anyone was doing anything with this substance on the table. The witness said, with all respect, I don't think you understand how that works. But when looking at the photograph, when you're talking about the truth and proving what is shown in the photograph, you can question, what does that photograph show? Perhaps it just shows that it's been set up to look like someone is doing certain things. The truth, however, cannot be tested by the photograph itself. And by the nature of it, therefore, it's just evidence. And this is the point that I'm coming to. It might be evidence that something was written down, something was said, that something was illustrated, something was on the table, as in that example there. Something was on the floor, such as a wine bottle or a wine spillage, or video footage that somebody was doing something, slabbing cabinets or something. If you're trying to prove the truth of something using that, what is otherwise hearsay or a previous consistent statement or whatever it might be, you need to test the evidence against what someone says in court. Because the evidence will either support what the person is giving in oral evidence, or they'll contradict it. And the photograph may contradict that evidence. For example, if someone were to say in oral evidence that they have pledged an amount of money to somebody, whereas there is previous video footage where they said something completely different. On the one hand, it might be hearsay, but on the other hand, it's used to contradict because it's a previous inconsistent statement with what they've now said. When you look at the ordinary and natural meaning of the words within any hearsay or previous statement, you can contradict or support what is said in oral evidence in court. And so it's the combination and the cumulative effect of the oral evidence given in court and being tested in cross-examination, together with the evidence, including hearsay where it's admissible. It's not always admissible. Some evidence never finds its way into court. And then afterwards you may be left thinking, if that were in evidence, it might have made the whole decision a lot easier. But you have to think about why it might have made the decision a lot easier, and it may be the wrong decision. Because, for example, if there were, let's say there were messages that indicated an intention to do something, but they were ruled inadmissible because they were hearsay, for example, then you might have, if you saw those messages, easily concluded that the person intended to do it. But there could be a number of different reasons why that message said that in the first place. There may be a question as to the authenticity or the originality or even the very truth of what is stated. For example, people do apologize for things they didn't do because they don't want the other person to be upset with them. If someone asks how they look on a certain day, the response might be, even by text message or whatever, you look great, even if they really think they don't. Because in fact, they don't want to have the argument, they don't want the dispute. So what they write down may not be the truth. So if you admit that message as proof of the matter stated, it might contaminate your decision as against evidence that is properly tested in court, proper oral evidence which is tested in court. And so that is the reason that there is a mix of evidence. Previous consistent statements typically inadmissible because they are in and of themselves typically devoid of actual evidence. They typically are just a statement and not evidence in and of themselves, and not independent evidence, not hard concrete photographic, CCTV or whatever other kind of evidence. They might just be exactly that, just a statement which is consistent with what you're saying now, which cannot be tested and therefore should not be taken to be reliable proof that what you are saying now is true. Inconsistent statements, on the other hand, are typically admissible because they contradict what you're saying now. And you are, I dare say, far less likely to contradict yourself if in fact your story is true all along. So again, with the police caution, if you initially give your formal account to something that you are not guilty of the offence, that's one thing. If you fail to mention something, or you give a different account in the first instance, and it contradicts your account at court, that's obviously going to be detrimental. So some of the rules and some of the tips that we come away with are consistency is key, because if there's a previous consistent statement, that's all well and good. You might be able to get that in as hearsay. It's less reliable as hearsay, but you may get that in as hearsay. But if it's inconsistent, then it's going to be an inconsistent statement. And there still might be hearsay elements to it, but either way, it would be a previous inconsistent statement. And so consistency is key. Having the evidence is key to underpin what you're saying. And then generally being credible. So the credibility comes into a lot as to when we are deciding whether someone is telling the truth or not. So let's say, for example, someone has pleaded guilty to a serious offence of misleading the authorities, for example. That should affect that person's credibility. It should really taint most of their evidence. Not necessarily all of it, not automatically all of it, but it certainly should weigh in the mind of the decision maker, the finder of fact, which in the UK in a civil trial is a judge, in a criminal trial it's the jury, and in the US and Canada it is a jury across the board. Nonetheless, it should weigh in the mind of the fact finder. Those are questions of credibility, and I suggest that credibility is important. And finally, after all of that, there is ultimately the human element, which is not necessarily based on evidence. It's not necessarily previous consistent or inconsistent statements or hearsay or anything else. The human element, in the end, is what many lawyers call the bit or the gap between the law and the truth or justice. And that is where we typically look to a jury to decide, to fill in any blanks, to add the human element, because we are all, to some extent or another, human lie detectors. Most of us, over time and a lengthy observation of people giving evidence and having their evidence challenged, we all determine, we make up our mind as to whether or not someone is telling the truth, whether they're credible, whether we believe them. And certainly when contrasted and compared with someone else, and as to how credible they are, whether they are telling the truth, then ultimately, once all the witnesses have been heard, all the evidence has been heard and tested, all of the inconsistencies put and either explained or not, we look to a jury to come to that decision, to fill in the blanks. And that's where body language comes in, but I'll save my thoughts on body language for another video. And of course there are plenty of others who are experts in the field in body language and psychoanalysis, etc. on YouTube that I've collaborated with. I have another collaboration coming up with Dr. Shaham Das, a consultant forensic psychiatrist. So I will link him in the description below now that I've mentioned his name. And we will discuss elements of psychology and psychoanalysis with respect to credibility, once again, and how we decide whether or not someone is telling the truth or whether they are lying. So I hope you found this an interesting overview as to how we as lawyers look at the evidence, and doubtless there'll be lots of questions as to each element, as to hearsay and so on. Do leave those in the comment section below. I love to read those. I love to spawn ideas of new videos and new ideas in general. And members' questions and members' comments always flag up because I can filter by those. So if you are a channel member, I will be able to see those more easily. Or if you're not a channel member, you can see the join button below. And as always, please do like the video, subscribe if you found any of this useful and interesting. And I will see you next time, and thank you for watching.